Hello students, today's topic is extinction of easements. Section 37 to 47 of the Indian Easement Act 1882 provides for the mode of extension of easements. So the first one is dissolution of servant owner's right. In this situation where the grantor ceases to have any right in the servant tenement because of some reason, then the right of easement ceases to exist as well. So when where the grantor is ceasing to have any right in the servant tenement due to any reason, then the right of easement also ceases. This has been specified under section 37 of the Act. Example of this is a X grants a piece of land to Y for a period of 20 years in 1970. In 71, Y imposed an easement in favor of Z. In 1990, Y's interest came to an end. Thus, easementary rights granted to Z ceases to end as well. So, the grantor who has given the right, his right is also ceased. So, automatically the right that is granted is also ceased. Expiry of time or happening of an event. When an easement is acquired on certain conditions or for certain purpose or for certain period of time, on fulfillment of such condition or purpose or expiry of time, the right of easement extinguishes as well, as in accordance with section 6 of the Act. So if one person is getting easement for certain kind of conditions or for certain kind of purpose or for a certain period of time, for example for 6 years, so when 6 years passes away, then the right also extinguishes, or if that condition fulfills or if the purpose is fulfilled, then the easement also right of easement also extinguishes. Now the third point, extinction by release, where in situation the owner of the dominant heritage releases the right of easement to the servant owner, the right ceases to exist. Such a release can be both expressly or impliedly made. So such kind of release can be expressly or implied. Example of such kind of release is, for example, P has a right to discharge water to the eaves of Q's yard. P authorized Q to construct a building to such a height as not to be able to discharge water. Q builds it and P's right comes to an end. So here is a situation where the owner of the dominant heritage releases the right of easement to the servant owner. So he has released his right of easement to the servant owner. So the right ceases to exist. Termination of necessity. When necessity terminates, the easement of necessity terminates as well. So when the termination of necessity, in this, when the necessity is terminated, the easement of necessity will also terminate. For example, A grants a piece of land to B, on which easement of necessity for B is the right of his way over A's land. Later on, B purchases a part of A's land over which he may pass to reach his own land. So now the necessity is gone, it is ended. So the right of easement has also extinguished. Useless easements. When easement is of such a nature that it is not useful or becomes incapable of being beneficial at any time or under any circumstances, then the right of easement ends. Permanent change in the dominant heritage. When the nature of the dominant heritage changes permanently with increase in burden on tenement, then the right of easement ceases to exist as the purpose of it was beneficial enjoyment of the dominant heritage. Example of this is that A's house is located such that he has a right of way by passing through B's house. Later, due to earthquake, B's house got cut off and thus the right of easement ends. So there is a permanent change due to the earthquake. Extinction by destruction of either of the heritage. So when either of the heritage is destroyed, the easement ends as it is essential for two parties to exist. It is not necessary that you have to buy the other land. Even if you are the occupier of the other land, then also the right will extinguish. Thank you.